Morning, everyone. It's Tim Toohey from Greenberg Glusker. Peter Jackson, my colleague, and I today are going to be presenting on the key 2023 changes to California privacy law. Very exciting subjects for all concerned because it affects almost everyone. Peter and I are both at Greenberg Glusker, and we are both in the department that deals with technology, IP, and privacy and data security. Good look at the agenda for today. Briefly, this is the agenda we're going to be covering. We're going to have an overview. We're going to talk about different types of personal information, what rights are in the new amendments to the privacy law that go into effect on the 1st of January this year, the important talking of sharing and ad ecosystems within the online world, employee privacy rights, which is a big new area, and other parties and relationships to other parties. But before we get further into this, we thought we would have a Zoom poll to see about familiarity with data privacy among those who are attending. So if you could launch the poll, please.
Yes. See how to do that here. So I'm seeing slightly different options than I did prior for that. But while we're doing that, I guess we can. Oh boy, yeah. Well, I don't see that.
If can't do the poll.
There we go.
There we go. Okay.
So yeah, we're just trying to gauge people's familiarity in the audience with the overarching topics to determine how granular we need to be throughout, and how much background context would be beneficial for the whole group. Well, it doesn't let me vote, so I'm just going to move on to the next slide.
Well, that shows that the poll certainly shows that people are familiar with privacy to some extent, and some are more than others. But I think that's the kind of range that I would expect. Before we get into the details that Peter is going to cover, we're going to talk just very briefly about what is privacy law. We all have heard of privacy. We know about the Fourth Amendment of the Constitution, which protects against unreasonable searches and seizures, but we do not have in the United States a constitutional right to privacy as some other countries. California has privacy in its constitution. And what we're talking about today is data privacy, privacy associated with individuals, consumers, employees, and others. And California has a pioneering privacy law, which has been in effect for some years now, and has been the model of other privacy laws. We don't have a similar thing at the federal level, but with California's changes this year, we are approaching something that is similar to other privacy laws. So I'm going to turn it over to Peter at this point to talk a little bit about what's the California Consumer Privacy Act is, how it's changed, and what we can look to for changes and action items this year in 2023 because of those changes. So Peter, if you could continue.
Yeah, so as Tim mentioned, CCPA, the California Consumer Privacy Act, has been in effect since 2020. As of this year, a ballot initiative that those of you who are California residents voted on in November 2020, along with potentially things that were top of mind in that election, voted into effect this amendment to that law called CPRA, although technically the amended law is still the CCPA. And CPRA made a bunch of changes, which we're going to go through today. But at a fundamental high level, we still have a disclosure and opt-out regime. And what that means is that if you're collecting the personal information of California residents and meet the jurisdictional threshold, which we can come back to later, but otherwise has not changed, that you're required to provide disclosures to consumers about how you collect and use their personal information. And the changes that have now gone into effect, although they won't be enforced until July, make some changes to the way that works. But fundamentally, opt-out is the basis. There's very few things that require consent from consumers under CCPA, except for the fact that you have to, get disclosure you have to give disclosure to consumers, and at times you would want to obtain their give them notice of these things. That's the other key piece. It's not necessarily a consent regime so much as a disclosure and provide notice regime. And the way that CPRA has changed this, just at a high level, is to provide that there are broader disclosure obligations, the types of things that you have to tell consumers about the ways that you collect and use information are a bit more depth and have a bit more depth and are more granular. There are some additional consumer rights, which Tim is going to go through in a few moments. Tim's also going to address the fact that as of now, consumers encompass employees, other personnel, and job applicants. So for businesses with employees in California and or job applicants from California, there are some additional nuances that you'll need to be thinking about. It includes, importantly, an opt-out mechanism that is automatic, which means that instead of consumers having to take an action to let you know affirmatively that they do not want you to do certain things with their information, that there are certain mechanisms by which they can automatically tell you that without having to take any affirmative action themselves. And we'll get into what that means and how to comply with it. And then finally, and this is something that is still kind of in a gestational stage, the law provides that the permitted use of personal information needs to be tethered to the reason that it was collected. And frankly, that is still kind of a nebulous concept, undefined, and it gets into enforcement that we don't really know what it's going to look like yet. So we will come to that in more depth later. As I mentioned, there's some things that aren't changing and there's some things that are changing. So the private right of action is still very limited and has to do with the failure to implement reasonable security measures in light of the type of personal information collected. That has not changed. So the plaintiff's bar is not going to have a gigantic new bite at the apple here. And this remains primarily enforced through the public enforcement regime. The caps on fines that can be assessed against businesses for failure to comply have not changed. But what has changed is that the primary enforcement of the law and the rulemaking authority for the law have shifted to an agency instead of the California Attorney General or the Department of Justice. And so what that means is that instead of, we just have a new enforcer and we have new rulemaking authority vested in an organization that was created just a few years ago by these changes to the statute that were in the ballot initiative called CPRA. We wanted to pause to note that the agency is funded, not as well as certain other regulatory bodies that enforce data privacy laws globally. It's allocated, at least $10 million a year in funding per statute. As of now, it wants to have 34 staff. I don't know where they are on that, but that's what their budget request is. So it's not a gigantic sprawling bureaucracy that's going to be checking for every little ticky-tack violation. It remains to be seen what their enforcement priorities are, but we don't think that it's necessarily going to be as robust as what we've seen in Europe with GDPR. And finally, the fines that are assessed by the agency are not used to fund it. So that, I think, is worthwhile to know. And then finally, although the law has now been updated as of January 1, the law will not be enforced. The as amended law will not be enforced until July 1, and it will be only enforced against violations occurring on or after that date by the agency. The California Attorney General continues to have the right to investigate and can pursue claims arising from the pre-existing law until the agency's enforcement begins in July. So finally, just as an overview, the ways that we think it's worthwhile to approach, the complying with this law, there's sort of two main categories. There's what do I need to disclose? And then there's how can I sort of limit my liability for what I'm doing? And so we're just going to do those in two different buckets. I mean, the first is for disclosure, it's important to think about the personal information you collect in terms of the categories that CCPA has statutorily defined. And we'll get into some of those, but Tim is importantly going to get to one of the new ones, which is sensitive personal information in just a moment. Where you collect personal information is important. For some businesses, it's entirely online, but even if you're collecting information offline, such as at a retail store or other location, there will be other ways that you need to provide notice to consumers of what you need to disclose. How long you retain information is a disclosure requirement now, and we'll talk about that, but it's something that we need to be thinking about in a way that we didn't before, because that's new. And then finally, when you disclose personal information to other parties, you want to be thinking about the purpose for that disclosure and how you can protect yourself in those situations. And from a liability perspective, it's not just disclosure, but it's also, are you able to fulfill consumer rights requests in the proper method. We'll talk about some of that a little bit later, but it's not just a question of putting some stuff in your privacy policy online as much as it is having the back-end technology to be able to process those requests properly. And then finally, do your contracts with third parties, with other parties, where you're exchanging personal information, limit your liability from misuse by those parties in the statutorily and regulatorily prescribed way. So Tim, I think we're going to move on to sensitive personal information now. Oh, never mind, there's one last slide. Okay. And that's just about notice of collection, which we discussed before. It varies depending on the location where you're collecting information, and you have to provide notice to consumers of what you're required to disclose by CCPA at or prior to the collection thereof. And so if you're offline collecting, such as at a retail store, you need to provide either a link, sometimes a QR code behind a placard would work, to the online version, or a printed form with the same information that you would provide if you were just providing it on the internet. Okay, Tim, now I think it's time for you to talk about sensitive personal information.
Yes, and before I do that, I failed to mention at the beginning, we're going to reserve some time for questions at the end. I understand that the chat is disabled, but you can put them, as some people are already doing, into the Q&A function. So I believe that's the correct way to do it. I've already seen questions, and we'll try to address those at the end, or to direct responses to the individuals. So, sensitive personal information. This is one of the categories which has changed and has been added to the law through the voters' amendment of the CPRA. And I think that it goes to really one of the concerns that have led to the California privacy law and led to the initiative, which is that consumers want to be more in charge of their personal information and want to have rights to do that. Now, it is true that there have already been other regimes, notably the European regime, that have been around a long time, that have already built in rights regarding certain information. But personal information, one of the big changes that came about in the CCPA as a privacy law was a broadening of the definition of what's personal information. You might have heard of the dreaded term PII, which was in the prior privacy law relating to data breaches. But personal information is a very different animal. It's much broader. It's any information that can be reasonably linked to a consumer, excluding some types of information that are here. But that really leaves a very broad range of information, from location to device use to attributes of a consumer that can be personal information. So think of it as a very, very broad term. Now, sensitive personal information is, if you go to that slide, is something that is new. This is information such as that frankly, is very sensitive to many individuals, relating to health data, things that are related to biometric information, for example, protected characteristics such as race, government ID numbers, financial information to some extent, and I think fairly importantly, precise geolocation information that's collected from a device that is within a quarter mile of the location. That is by no means an unusual proximity or unusual sensitivity of location under this day and age. And it can contain contents of email or text messages. So this is the definition of sensitive information. But the important thing on this, because this regime regarding sensitive information is not yet settled through regulations from the agency or otherwise, is that if you collect that type of information, if this sort of rings a bell, you need to disclose the use in a privacy policy. And you also should think very carefully about whether you need and want to retain that information, both because of its of the CCPA requirements, and also because a data breach of that information could be very damaging to individuals. So the CPA now provides an opt-out link if you do collect that information, if it is used for certain unnecessary purposes. Now that is a vague word, unnecessary, but if it's used for direct business purposes, such as collecting social security numbers for applicants or something of that sort, that is not going to be an opt-out requirement. That's a requirement if you want to join a payroll and want to be able to be have file taxes and things. If it's disclosed for purposes that aren't business purposes or not necessary, then you have to provide an opt-out link in addition to the information you provide in the privacy policy. So this is an important thing for a certain segment of businesses, not necessarily for every business, but it can provide a different opt-out right that has not existed before. So what are the rights? This is probably goes to one of the core and important areas under the CCPA. You know about privacy policies, you know about disclosures and privacy policies. What rights do consumers have? Now, these are rights that California consumers have, and that now includes employees. The first is a right to correct, which is a new a new right that was put into effect to allow consumers to correct certain information that businesses hold about them. You need to disclose this and the other rights and privacy policies and provide a method for the exercise. Those may be called something like a data request from a consumer, and you have to provide a method in which that request can be made. And if you do respond, as you are required to within 45 days, you have to verify the consumer's identity, but not through asking for something like social security numbers. Commercially reasonable efforts to comply are needed. And correction, of course, should be proportional what the importance. I mean, it's perhaps not adding a dot to the initial after a middle name, but changing addresses and things. So you don't have to go back through every record to do this. It has to be somewhere within the range of reasonability. The next major right is the right to know. And that is perhaps the most important right. This is the right of the consumer to request information about specific pieces of personal information and the categories of personal information that a business is collecting. There has to be a means, again, to exercise this right, typically something called the data access request, although that term is not defined in the CCPA, and a method that is provided through a portal, email addresses, or physical addresses in a privacy policy. And a business has to respond to this by providing information in a format that is easily understandable to the average consumer, as you can see here. And that right is likely to become an important right in the context of employees, as we'll see. There's also a right to remove certain information, which isn't mentioned here. That relates to a very small category of information, given that there are many exceptions to that, including retaining information for legal purposes. Finally, as there's a right, it's in a way, it's a right, it isn't a right for an information request, but businesses that collect information cannot retaliate against its personnel or applicants or consumers for exercising any of these CCPA rights. And those rights to correct, the right to know, the right to remove information. If someone exercises them, you need to follow the procedures that are set forth, respond within the correct amount of time, which is generally 45 days, and you can't retaliate against an individual for exercising those rights.
And that's going to be something that plays an interesting role in terms of how it interacts with the right to opt out of the sale or sharing of information and limiting the collection of sensitive personal information. Since at times the right of no retaliation will create interesting implications for those opt-out exercises.
Peter, I think you're going to deal with that one right now, which is a big one within the privacy community. Again, it doesn't apply to everyone, but I think Peter's going to show you some interesting ways in which this is going to play out in California, starting now.
So one of the biggest changes that CCPRA makes to CCPA is to upend what it means to sell or share information. Previously, sale was defined somewhat narrowly as being a sale of personal information for monetary or other valuable consideration. And because that basically exempted from the definition of sell many ways that businesses monetized effectively personal information, such as by sharing it with third parties to optimize advertising, the amended law provides for a new definition of sharing, and basically for today's purposes treats those two ideas as pretty much the same thing from a disclosure obligation perspective and from a liability perspective. So share now means any disclosure of personal information for targeted advertising. That sounds bizarre. Let's get into what that really means. So when I say targeted advertising, CCPA is talking about cross-context behavioral advertising. And that means using personal information collected on one domain, such as my location or my name on perhaps your business's website, and then providing it to a third party for the purposes of enabling targeted advertising on any other domain other than one's own. And it does not matter if the advertising is for the business that I intentionally interact with or for a third-party business of some kind. And that seems all very like esoteric and theoretical. So we thought it would be helpful if we just sort of provide an example of how this works in practice using an e-commerce website that some of you may be familiar with. And we just wanted to show sort of how this works if you load lululemon.com on a standard browser. And this is sort of a screen recording of what happens there. So as you can see in the background, lululemon.com is being recorded, and I've opened the developer tools menu to show all of the interactions between the browser and this website. And as you can see, there's a lot of interaction with Google, Tag Manager, Analytics, Facebook, a bunch of other third parties that you may not have heard of, Snapchat being one of them. And the purpose of some of these collections and some of these interactions is going to be sharing information about my visit to lululemon.com with that third party, often for the purpose of enabling ads. And if you do this in Sephora, you can see here that these are third-party trackers that are, interacting with information that's being collected by this website through this website's basically facilitation of these tools directly. So importantly, what CCPA does is provide for a opt-out right from any sale or sharing, and we're going to get to that and what that looks like. It's a homepage link, but sort of the most far-reaching change that we've seen is the enforcement of an existing standard with respect to sales, where if a consumer enables a preference signal on their browser or device to instruct any website that they visit that they do not want their personal information to be shared or sold with a third party, the website is supposed to automatically respect that by turning off all tracking of that user or sharing of personal information of that user on that domain. This was the subject of a sort of enforcement sweep last year targeting e-commerce businesses by the California Attorney General, which at that point had enforcement authority under the law. As you can see, it led to the images at right from the first published enforcement action, which was against Sephora, which was among the e-commerce websites that did not respect opt-out signals sent by a particular protocol called global privacy control. And today there are various ways that consumers can put that into place, but it's not the easiest thing in the world. It's not a matter of clicking a button. You could use a browser like Brave, which automatically sends it. You could download an extension for Chrome, but it's worth thinking about the ways that now that this right is in the law, that it might be integrated more commonly into the ways that we interact with the internet, such as Apple making this a default setting that any of us could enable on a device or within a browser. So I want to go back to Lululemon and show you what happens when you load the page in a different browser where global privacy control is enabled. And you'll see here that this is sort of the same thing that we saw before, but the domains that are interacted with are primarily first party. You won't see Facebook, Google, and various of those other third party websites on this list, which is helpful to know. I'm going to skip over the rest of this video because it's not that exciting. But you'll see that if you look at the data that is being collected and maintained on your device when you've accessed it from a browser like Brave, is that the website is actually has a tool to divine whether the user has enabled global privacy control, and that's reflected in the data. So here you can see that Lululemon has detected that my browser had global privacy control enabled, and therefore has limited the collection of personal and sharing of personal information with third-party trackers. So in addition to the opt-out right, in addition to the preference signal option that consumers now have, there's the sort of more familiar, if you're browsing the internet style, homepage link requirement. So if you are selling or sharing information, as Chanel has done here on the right, you can see that you're required to put a do not sell or share my personal information link. And that is supposed to have the effect of opting the consumer out of those types of uses of their personal information. You can also have it linked to a page where then the consumer can affirmatively say that. Our recommendation is that that should just be a one-step process. In any event, you'll see this on websites with increasing frequency. You may have seen do not sell my personal information before. The new statute provides that it's supposed to say do not sell or share my personal information. And then finally, as Tim alluded to earlier, if there are sort of unnecessary uses of sensitive personal information, or there are disclosures of sensitive personal information for things that are not a business purpose, aka selling or sharing, that the limit the use of my personal sensitive information link is required, as well, as you can see at bottom right from cottonelle.com. Finally, as intersects a lot of e-commerce businesses, there's an existing sort of disclosure requirement for financial incentives, and that's an exchange of personal information for some kind of consideration. The most typical version of this that you'll see is 15% off your first order if you sign up for an email list. There's a disclosure obligation for those things under CCPA. Here's an example on the right. And this can be interesting because if this conflicts, if someone's participation in a financial incentive program conflicts with a signal that is sent or an opt-out right that is exercised, a business is required to honor the opt-out and opt the person out of the sharing of information and or the disclosure of the sensitive personal information, but you are allowed to notify the consumer that that is going to happen and give them the right to opt back in to the extent that their ongoing use of personal information or disclosure is required to obtain that financial incentive. An example of that would be like an ambassador program where you earn some remuneration in order to by sharing a link to a brand's website for sales. Okay, move on. And Tim is going to talk about the fun bailiwick of employee privacy rights.
Now, some of you may be thinking as you listen to Peter's presentation that you don't sell the information of any of your consumers. Some of you may be thinking that a lot of what we've been saying today does not, apply to your particular business, but almost everyone who's probably participating in this deals with employees. And if you are subject to the CCPA, we should mention that not every single business is subject to the CCPA because they may not have sufficient revenues as defined in the CCPA or handle a sufficient number of records, or they may be a not-for-profit business. But most businesses are going to have employees. Now, the interesting thing about this is that, next slide, please. Prior to January 1st, 2023, the personal information of applicants, personnel, contractors, and others, generally what I would call employee personal information, was exempted from the CCPA. And this exemption persisted for some years. That was added by the legislature. It continued to add it, but it is expired now as of January 1st, 2023. There was a last-ditch effort to try to keep this exemption in place, but it's not in effect anymore. And so enforcement will come into effect on July 1st, 2023. So the real question then becomes, how are employers going to be dealing with privacy issues in regard to the employees. Privacy issues in regard to employees are quite a different thing than privacy in regard to consumers who happen to buy your goods or services and like. So you may have to have a separate privacy policy for your employees because the rights that they have may be somewhat different in the way that they are affected and their scope than for other consumers in California. So an employer, which is a business, which is a very broad term, so that's essentially saying an employer, must include, that's not exempt from the act, must include the same privacy disclosures to applicants and employees as other businesses do. Excuse me. This is, excuse me, as I said, I'm just getting over a slight cold here. So this probably should be done through a separate privacy policy. And what comes along with this is very important because the employees have now separate rights that they can exercise vis-a-vis the employer, the ones that we talked about before, particularly the right to know, the right to delete, and the right to correct. It's unlikely that you will have a sale of employee personal information. So employees may serve requests, data access requests to employers, and employers have to be ready to respond to those requests. It's complicated by the fact that in California, we have a very comprehensive labor code, which already has a provision to obtain a personnel file. But these requests are different, and they will require a business to categorize and detail information of the employees. Now, we don't know how this will be used or weaponized. There is no private right of action in regard to this, so it may not become a litigious matter. But employers should map the data and train employees to respond to the request, particularly perhaps through a different portal that they use, and preferably through an HR function. Responses to these requests have the same timeline as any other requests. You have to provide the information free of charge within 45 days, with a 45-day extension if necessary. Certain information does not have to be turned over or deleted. Excuse me. And that information, may include information that's maintained for legal purposes, for other exemptions, but we're in a brave new world here with these requests. We don't have guidance from the agency as to how to respond to these requests. The whole statute in CCPA is not written in terms of employees. It's not an employee-specific law. It's trying to fit a round peg into a square hole. Next,
right.
Please.
I think that's probably all we have on employee requests, but yeah, as Tim mentioned, the deletion request rate, as with any other type of consumer, so whether they're an employee or an applicant or just a California resident, the deletion requests may be denied for a variety of reasons, such as information that's necessary to perform a contract with the consumer, such as paying the person their payroll. We may need your social security number, providing or complying with legal obligations. Like we need your social security number to meet our tax, disclosure obligations as well. And those are relatively well defined. But as Tim mentions, absolutely the employee disclosure obligations are completely untested, and it remains to be seen how much exercise we will see of them. So we're going to move on now, since this is kind of a survey day of various changes, to the subject of disclosure of information to other parties and some ways that businesses can protect themselves before moving on to questions. And because CCPA uses a lot of terminology when it comes to outside parties, we're going to try to take this slowly, and I think maybe answer a question that I saw in the chat about the definition of a business that needs to comply with the statute. But first, I'm just going to talk about why this kind of matters in terms of these disclosures to outside parties. And So if you have a properly written contract that complies with certain statutory requirements, you as a business that controls the collection of personal information or collects personal information can be precluded from liability for its misuse if you disclose it to another party. And these fall into three main categories of outside parties: what CCPA defines as a service provider or contractor, which we'll talk about why that's perhaps not a super important distinction for purposes of today. And then the other category being third parties. But first, who's the first party? And this came up before, where we have business in quotation marks. CCPA applies to businesses. The disclosure obligations relate to businesses. And a business is any party that collects or controls the collection of personal information and meets the jurisdictional threshold that we've talked about earlier, $25 million in trailing calendar year revenues. So as of today, that would mean $25 million in revenues in 2022, or that collects the personal information of more than 100,000 California consumers. Surprisingly, we've seen clients that meet the latter threshold and not the first one, because their website may be visited by millions and millions of people, even if they don't have $25 million in revenue, and therefore may meet the jurisdictional threshold for the number of residents whose information is collected, despite not meeting the revenue threshold itself. But those are the two main prongs, and you can go into that further if you like, but those have not substantially changed except for the dollar amounts since the CCPA first went into effect in 2020. So the first party is the business, and I'll sort of talk about this from that framing. So who are service providers? Service provider is any party that receives personal information from a business under a written contract that provides that the service provider will only use it for business purposes, which we're going to come to in a second. But those are sort of legitimate operational purposes and pretty broadly defined in nature. We'll come to that. And importantly, this written contract, the service provider has to prohibit the service provider from selling or sharing the personal information that is disclosed, using it for any purpose other than those business purposes that the contract defines, such as its own commercial purposes. Commercial purposes is basically any sort of gain of one's own from the information. We can go into the statutory definition, but I think business purposes is where we should focus our attention. And then also the service provider has to be prohibited from combining the personal information received from the business with its own personal information that it may have collected elsewhere, or any other business's personal information, unless it's necessary for it to do so in order to carry out the business purpose that the contract defines. Okay, so I've said business purpose a lot, probably makes no sense. I think we're going to talk about it briefly. So the statute defines this term, but just to crystallize, it's broadly defined operational purposes that are necessary for running, an online business and or physical business if you're operating in both locations. So that would be providing customer service, such as you could use a third party to manage a support queue for questions from consumers, facilitating payments, so your Stripes, your PayPals, your other payment card sort of acceptance providers. Order fulfillment, if you integrate Shopify, for example, in order to process orders, security on your website, like a Cloudflare, in order to prevent malicious traffic from coming into your website that shouldn't be there, et cetera, et cetera. Additionally, business purposes encompass maintaining the quality or safety of your service or devices. We can talk about the exact reason for that, but that is another one of the broad sort of operational purposes that's here. And even some ad-related purposes can be business purposes. Just what's excluded is those that are about providing cross-context behavioral advertising. However, if you sort of partner with somebody to provide display ads on your website, and they're not targeted to any individual on that basis, they're just an ad for some product that applies to all of your website visitors, that is not personalized advertising, and disclosure, of some information for that purpose would be a business purpose, and that party could be a service provider to you under CCPA. Contractors, for today's purposes, we can think of as service providers that have somewhat broader usage rights than ordinary service providers. but for today's purposes, not a meaningful distinction. That is a red line at right of just the two definitions next to each other. There's a lot of bad information out there about the distinction between these two concepts, but for purposes of precluding liability, in each case, the point is to have a written contract that provides for compliance with this definition statutorily. And then the business itself can be precluded from liability for the actions of that party, as long as it doesn't know, or should have, or reasonably should have known that the recipient would violate the prohibitions in the contract at the time of the disclosure. So finally, that's sort of the first bailiwick. You've got your service providers and contractors, and the written contract is supposed to specify the things that we talked about before. The other category is third parties, and this is any party to which information is shared or sold. So in the examples that we've seen earlier, it would be, for example, if Google is controlling, is on your website and collecting personal information, and it's for the purposes of, tailoring advertising to individual users, either your own or other parties on other websites, that would be a sharing of information situation. Google would be a third party. And in that case, there's no liability to the business for the misuse by the third party if the written contract with the third party requires the third party to adhere to the same level of protection of personal information that CCPA requires of the business. Sort of importantly here, that would be, implementing security measures and protection measures that are appropriate to the nature of the information. So with respect to sensitive personal information, it would be somewhat higher than something like someone's just name and, email address. And then finally, this does not apply to the extent that the personal information concerns consumers who've opted out of selling or sharing of their information. So this isn't an end run around that requirement for compliance. You can't be excluded from liability if the third party obtains information that you weren't supposed to sell or share in the first place. And that applies both to personal information and sensitive personal information. And then finally, if it's relates to a minor, you do need to have had their affirmative consent to their opt-in for sale or share. And so you're not going to be excluded from liability to the extent you've got information of minors that's going in there, unless you've obtained that affirmative consent. All right, so we wanted to leave a lot of time for questions, and I think we have successfully done that. I probably also
I have a question, Peter.
Yeah.
Which is, what is the practical effect of this third-party contract requirement on a small, medium-sized business? What does a business have to do? What do they have to look at, and what do they have to really put in place now if they haven't put it in place before, in terms of these agreements with third parties? Can you just boil this down to some practical advice?
Okay, I want to say first of all that if you're familiar with the term DPA or data processing agreement or addendum, that is not, strictly speaking, you don't need a separate contract here apart from the one that you may already have with this other party with whom you are exchanging personal information. You don't need to have a special rider necessarily. You can do that, but you need to have in your agreement, in your written contract with that party, the statutorily prescribed prohibitions on, these types of uses of information and an explanation of what the permitted use of information is. So typically speaking, in a contract between, let's just say, me and Tim, if we were businesses, I'd say, Tim, you can have this personal information for the purpose of providing you the analytic services to me that you do when you review my work product on occasion, and you can't use it for any other purpose. You can't use my name for any other reason. And I was, we'd provide that you're going to be that's a business purpose, and that you're going to comply with CCPA's requirements as a service provider to me, and then I'm not going to be liable for your misuse of that information if you do that, because I put in my written contract with you the things that it needs to say and you've agreed to them. So for, as a practical day-to-day matter, on a going forward basis, if you're a business, you want to be looking at what's coming in terms of revisions of agreements and new agreements, and trying to get in there some more granularity around if there is an exchange of personal information, what category, what information is going over from a, just think about that and what the use of that is supposed to be. And it falls into the, if it's for a business purpose, to provide that, as between the parties, that one is a business for purposes of CCPA, one is a service provider for CCPA purposes, and that each party will understands and will comply with those requirements throughout the performance of the agreement. We've not yet seen exactly how ticky-tack anyone is going to be around the written contract requirements. For the most part, what we've seen is, sort of just what I said, and not a ton of granularity around statutory citations and things like that. But it's just something to keep your eye on going forward if you're in-house counsel or otherwise at a business and trying to get a hold, get a handle on the use of personal information that you're exchanging outside of your organization. Does that sort of help answer that question, Tim?
Yes, I think so. I mean, it's really for the protection of the business. The business have to,
Correct.
To really see this as something which is a commonsensical requirement. You should be protecting yourself if you're sharing personal information with a third party. And that's why I think we've seen data protection, data agreements of this sort that stem from GDPR and have been very successfully, I think, enacted. It's not going to pertain to every third party that you have. But if you're sharing personal information, this is really saying that you need to, protect yourself as a business, making sure that any third party that really handles that and deals with it, almost any, can adhere to the standards. So,
I'll say that in the online behavioral advertising environment, if you're a business that's in there, and you may have many contracts with third parties relating to this, you'll see that a lot of those parties will have basically added in either via amendment or like a link in their terms, sort of the idea of compliance in accordance with these categorizations of the roles of the parties under CCPA. It's still important to make sure that those are correct characterizations, that they match what's being shared and the purpose of why. But it's not. We are already seeing an increased focus on this in a lot of vendor agreements. From the business's perspective, it's just important to make sure that they're in there. And also, to the extent that you're routinely a third party or a service provider to a business, you want to, the benefit to you is that you're able to reroute any requests from consumers to the business instead of having to process them yourself.
So should those parties really proactively be insisting on their own form of an agreement if you are routinely being asked to deal with personal information for a business, or will the business have its own form, or does it depend on bargaining power?
It's beneficial in most cases to both parties, but definitely probably more important for a business because it helps you get a handle on the exchanges of information that may be going on, and also reduces the likelihood that you could be held responsible for the actions of some other party that received from you, such as if it was breached and you realize that a bunch of unencrypted information about consumers who interacted with you was actually disclosed to a third party and suddenly found its way out into the ether.
So that makes a good deal of sense. I had one sort of question, and to turn to these other specific questions that we have here about, business has a privacy policy. Let's say they have a privacy policy in existence as of this date that hasn't been revised for a couple of years. And believe it or not, we do see a few policies that don't, no one wants to spend time and money on revising the privacy policy. What are the big changes if you're going to revise a privacy policy you have out there, taking away what we've talked about today? What are the big things you should consider that come to your mind? That I can add any as well, Peter.
Yeah.
That needs to be done. If you have a privacy policy, let's assuming you're not the size of a Sephora or Lululemon, but you are a small, medium-sized business with some online presence and, of course, employees. What do they need to do? Do you have a top 2 or 3 things that need to be changed?
Easy low-hanging fruit is to disclose the retention period or how the business determines how long to retain personal information. That's sort of an independent and new requirement, relatively easy to describe. basically a paragraph that says you take into account the considerations that CCPA says that you have to take into account in order to determine how long to retain information. If you can't say exactly how long you do, which most businesses can't, I would say that's number one. I would say to the extent that you're saying that you need to figure out whether you're sharing. And if you are, that you need to say that and provide the opt-out mechanism. It's going to be probably it has been and probably will continue to be a focus of enforcement actions. And then I would say additionally, throughout, you want to make sure that you're describing the nature of the collection and use of information properly. It's probably not the same as it may have been 3, 4, 5 years ago, even 12 months ago when you initially drafted it, and reflecting those changes throughout is probably what I'd say is number 3. Finally, providing notice in a manner that if you're making changes and you need to make changes, providing notice to consumers, is quite important. CCPA prohibits, collecting and using information in a manner that's inconsistent with the existing disclosure unless you provide a fresh notice to consumers of those changes. And that could be, prominent notice on the domain where this is being collected, a pop-up, an email to consumers to the extent that you have their email addresses, things like that.
Yeah, I would add sensitive information. If you're collecting it, needs to be disclosed, and there needs to be the proper rights associated with that. And I think a biggie is that your existing consumer-facing privacy policy for customers may be quite different than what you have for employees. So let's go to a couple of specific questions. There's a question: if you have a global privacy control activated, does that theoretically have the same effect as clicking on the "Do Not Sell" or "Share My Personal Information" button? I think that's one for you.
That is a yes. It should not have any, that is the purpose of having the global privacy control on, is so that you don't have to affirmatively as a consumer click on the link on every website every time that you want to exercise that right, that it happens automatically for you. And I think perhaps relatedly, and we didn't get into this because it's all very complicated already, but if you are compliant with the global opt-out preference signals and you're processing them properly, the homepage links can be somewhat different, and you can avoid having to post them in the exact manner that we described in this presentation. We can get into that. If you're a business that is thinking about that, happy to talk to you offline about that further, but it is an important thing to think about going forward.
We have a question: does a business need to timely respond to a data request from a person who has made more than the number of requests allowed in a year? I.e., does the business need to respond in 45 days to tell the person you have already made 2 of these requests this year, or can the business not respond to excessive requests? I guess I'll respond to that. This is referring to the fact that there are certain exemptions and exceptions, I guess, to the right to know and other rights. And an employee cannot make more than or a consumer cannot make more than 2 requests in a 12-month period. And the employer can charge a reasonable fee for manifestly unfounded or excessive requests. My recommendation would be not to ignore a request. I'm interested in what Peter thinks on this, but to acknowledge the request and cite the exemption and say you've made more than 2 requests this year, and to say that we're not going to respond to it and we're entitled not to respond to it under the law. Do you agree with that, Peter?
100%. You can set that up in an automated process so that if you're creating a robust compliance program with this, if you're selling or sharing, you're required to have a web-based form for fulfilling requests under the rights to know, correct, and delete. And if you got that tied into a database and you sort of have a queue going and you're able to automatically respond to some of these requests, I think that's a completely defensible manner of doing so. And really it's quite a broad right that consumers have, and exercising it multiple times more than the statutorily required to, I believe, it does not seem to be something that anyone's going to be upset about if you're saying no.
We have a fairly specific question as to, Private Attorney General Act, whether PAGA is not applicable because the agency is the only entity with enforcement authority. And of course, those in the employment field are very well aware of the PAGA or PAGA. I think that is correct. It is not applicable. it's really unclear how the employee access requests and the rights given to employees are going to really intersect with other laws, including labor code provisions. But here we have an act that has limited private right of action to begin with. So it's really going to be enforced with the agency. And we don't know what's going to happen with that, but it looks like it's not going to be happening. Look at the,
Yeah, I'm not sure if it matters, but because I don't know about the PAGA, but I will say that the Attorney General retains concurrent authority to enforce CCPA as amended. And the interaction between the agency and the AG are basically that the AG can simultaneously investigate, and if they decide to do so, that the agency will stay in sort of its enforcement action upon request. But the administrative action that are enforceable, in a civil action subsequently by the agency if they determine that a fine should be assessed, and then the civil action that can be brought separately by the AG, although you can't be assessed penalties by both. Those are sort of two distinct enforcement pathways, and so I would just bear that in mind as we think about that answer to that question.
Just looking through the questions, since we're running out of time, and we'll try to respond to all the questions individually. But we do have one here. How would you characterize the use of a third-party service on a company's website that uses browsing information of the visitor while on the company's site to identify the visitor's email address so that the business could send them marketing emails to the site visitor after they leave the site? Is this considered targeted advertising?
I'm reading the question now from Rachel Corcoran, which is a detailed question.
May require additional thought, but I think that, if you're using the browsing history of someone to send emails, it might depend upon the content of the email. That to me does indicate, a targeted use of someone's browsing history. It may be an expected use that the consumer is expecting, but it really kind of would depend upon the nature of the emails themselves. But it strikes me, is that something that a consumer really expects to browse a website?
That's a collection of information from other sources, right? So we're not talking about the first party business collecting the email address in this case. It seems like it's being inferred from browsing information. And that's fine. You just want to disclose that your website does that in terms of the sort of the source and how you collect information. You're saying basically that, you may get your email address and it's not going to be something, you're not always going to provide it. As far as but again, opt-out regime. I don't think that would be considered targeted advertising because it's not cross-contextual behavioral advertising. You're not using it to advertise third-party products. But to Tim's point, if you were to do that, you were to send emails about the third party for that purpose, you'd be really on the borderline there. I would say that, other law would apply here. The CAN-SPAM Act with respect to email addresses requires an opt-out in every email.
Yeah.
And then I would be very wary of this fact pattern with texting. If you were to infer someone's phone number in this manner, and then you were to text them, you would not have affirmative opt-in consent and could be liable under the CAN-SPAM Act.
Yeah, I agree with that. The opt-out for email, but it strikes me as slightly unexpected, slightly creepy to get an email from simply browsing a particular website. I'm not entirely sure how that all would work mechanically, but we're very close to the time here. I want to thank everyone for attending this presentation. We've had a great group of people, lots of questions. We're going to try to get back to you on all the questions that you've answered. There's information in the chat was placed regarding the CLE materials that will be MCLE materials that will be available. And we ask that you please, it will be distributed look for this email coming. It's going to be distributed to all attendees within the next 24 hours. If you have any questions regarding other matters that were raised today or other matters relating to privacy, data security, feel free to reach out to Peter and myself. And with that, I'm going to thank everyone for attending. And I think we're right on the hour. So have a great rest of your week and a great end to your MCLE compliance period. Thanks very much.
Thank you.